Hello friends, this is Sanjay. This is part 2 of the series covering the Bharatiya Sakshya Adhiniyam as per the standard LLB syllabus. In this part, we will focus on some important definitions given under section 2 of the BSA. Since the BSA is applicable to all civil and criminal court proceedings, whenever these terms are used in any court proceedings or even when they are used in any other legislations, their meaning will be as per what is given in the BSA. In the BSA, various terms are defined under section 2. Before we look at each of these terms separately, I will explain all of these terms very briefly and also show you how they are connected with each other. First of all, there are facts. Now facts can be about objects or events or feelings or emotions or anything. In regular usage, the term fact means something that is known or proven to be true. But in the legal context, a fact is like just a statement. It may be true or it may be false. The earth is round. Mr. X is a man. He had a phone. The phone is missing. The phone was stolen by Mr. Y. Mr. Y is a physically disabled person. Mr. Y had idlis for breakfast on the day the phone was stolen. Now all of these are facts. But some of these facts may be true and some may be false. A fact has no legal value unless it is accepted by the court as being proved or as being true. When this case about the stolen phone reaches the criminal court, all the facts can be classified into three categories: facts in issue, relevant facts, and irrelevant facts. Facts in issue are the central facts that need to be proved or disproved to decide the case. So the fact that Mr. Y stole Mr. X's phone is the fact in issue, because if it is proved, Mr. Y will be punished. If it is not proved, then Mr. Y will be released. Then there are relevant facts, which are facts directly connected with the facts in issue, or they are connected to another relevant fact. Mr. X had a phone is a relevant fact, because it can be stolen only if he had it in the first place. So Mr. X will have to prove that he previously had a phone and now it is missing. Mr. Y was seen entering Mr. X's apartment. This is a relevant fact, because if it is proved, it shows that Mr. Y had the opportunity to steal the phone. Mr. Y is physically disabled is also a relevant fact, because it may show that Mr. Y could not have possibly stolen the phone. Some of the other facts like the earth is round, Mr. X is a man, Mr. Y had idlis for breakfast on that day are all irrelevant facts, because they are not directly connected with the facts in issue. It doesn't matter whether these irrelevant facts are true or false. With the facts in issue and relevant facts, some of them need not be proved, and the court may take them as a proved fact and use it in the proceedings. The Bharatiya Sakshya Adhiniyam also has the concepts of may presume and shall presume. With some facts, the court may presume that they are proven facts, unless and until the fact is specifically disproved. Here the key word is may, which means that it is left to the court's discretion to consider the fact as proved or ask for evidence. With some facts, the Adhiniyam says that the court shall presume them to be proven facts, which means that it is mandatory for the court to consider these facts as proven, unless and until such facts are specifically disproved. If a fact does not fall into the need not be proved or the may presume or the shall presume categories, then it is a normal fact, and the court will need evidence to prove or to disprove the fact. The evidence can be oral or documentary. If a security guard who saw Mr. Y entering Mr. X's apartment gives testimony, it will be oral evidence. In documentary evidence, the format of the document may be physical or electronic. If Mr. Y signed a visitor register before entering Mr. X's apartment complex, then the register will be physical evidence. If there is a CCTV recording showing Mr. Y entering Mr. X's apartment, it is electronic evidence. Old-fashioned CCTV cameras would record on tape, which was analog format. New CCTVs record onto a hard disk, which is a digital format. The Sakshya Adhiniyam specifically recognizes all valid electronic evidence, whether it is analog or digital, as valid documents. After examining the evidence that is presented, the court can evaluate the facts in issue and the relevant facts and take them as facts which are proved, or as facts which are disproved, or if the evidence is not sufficient, either ways. The fact is taken as fact not proved, where the court cannot conclude whether it is true or not. Another concept included in the BSA is about conclusive proof. If fact 1 is proved, and if as per the BSA fact 1 is considered as conclusive proof of fact 2, then fact 2 is automatically considered as proved. Next, we will go through each of these terms in a little more detail to see how they are defined in the Bharatiya Sakshya Adhiniyam. Conclusive proof is defined under section 2(1)(b). As I have already explained, if the Adhiniyam declares that fact 1 is the conclusive proof of fact 2, and if fact 1 is proved, then fact 2 is considered to be automatically proved. This term is used in section 35(2), where it is stated that if any other court with a proper jurisdiction passes a valid judgment or a decree or an order conferring some legal rights to a person, then the current court will automatically consider it as a proven fact that the person has those rights. The person does not have to specifically prove the existence of such rights. Another example is when a court grants a decree of divorce, then the decree is conclusive proof that the marriage is dissolved, and this cannot be challenged by presenting evidence to the contrary in any other proceeding, unless of course the proceedings are to set aside the original decree itself. This term conclusive proof is also used in section 116, where it says that if a person is born during the continuance of a valid marriage or within 280 days thereafter, then the person will be considered to be a legitimate child of that man, unless it can be shown that the couple did not have physical access to each other during that time, which means that conception could not have happened. Document is defined under section 2(1)(d). This is one of the most important definitions in the BSA, because fundamentally there are two types of evidences, oral and documentary, and anything that is not oral is documentary. So this term document is quite important, and it has been used more than 180 times in the Sakshya Adhiniyam. Chapter 5 sections 56 to 93 and chapter 6 sections 94 to 103 specifically deal with various types of documentary evidence. In addition, this term is used in several other sections as well. So this term document is one of the most basic and fundamental concepts in the law of evidence. Probably the most important evolution from the old Indian Evidence Act to the current Bharatiya Sakshya Adhiniyam is the acceptance and the recognition given to electronic and digital records. This was essential because most of our communication and commercial transactions these days depend significantly on electronic and digital systems. Since document is one of the most important and widely used terms in the Sakshya Adhiniyam, the definition of this term has been expanded to include electronic and digital records as well. One of the illustrations under this section also gives examples of different types of electronic records which qualify as documents. The definition of evidence has also been expanded. Further, section 61 makes it clear that electronic and digital records will have the same legal effect, validity and enforceability as any other physical documents. Because technology keeps changing very fast and the Sakshya Adhiniyam may not always be up to date, section 2(2) of the BSA provides a connection to the Information Technology Act by stating that words and expressions used in the BSA but defined in the IT Act of 2000 will have the same meaning as what is intended in that act. So terms like digital signature or electronic signature, which are used in the BSA but not defined here, will have the same meaning as per their definition in the IT Act. So whenever the IT Act gets updated, the Sakshya Adhiniyam is also automatically updated. To summarize, the BSA not only recognizes electronic and digital records, it also gives them the same legal status as physical records. The preamble of the BSA states that this act exists to address the rules and the principles of evidence. So the term evidence has to be defined. Evidence is anything that is submitted to prove or to disprove a fact in the court proceedings. Evidence is defined under section 2(1)(d), which classifies evidence into two categories. All statements given by the witnesses before the court, including those given electronically, will be oral evidence, and all documents including electronic and digital records, will be documentary evidence. In a later part of the series, when we discuss documentary evidence in more detail, we will see that the BSA classifies documentary evidence as primary and secondary. Now that we have an overview of the concept of evidence, you should also note that Section 3 of the BSA says that evidence may be given of facts in issue or relevant facts to prove or to disprove them. So the definitions of fact, facts in issue and relevant fact becomes important. Fact is defined under 2.1f, facts in issue under 2.1g and relevant fact under 2.1k. If you read through the definition of fact, you will see that anything can be a fact. It can be about physical things or even mental or psychological things like feelings, emotions, etc. As I have mentioned earlier, from a legal perspective, a fact is just like any statement. It may be true or it may be false. So a fact has no legal value unless and until it is proven as true or proven as false, for which evidence is submitted. Now, facts in issue simply means the core issue that the specific court proceedings are all about. In our phone theft case example, the fact in issue was that Mr. Y stole Mr. X's phone. Everything that is being presented, argued or debated by the prosecution and the defense in the court proceedings is either to prove or disprove the fact in issue. Relevant fact simply means any fact that is directly connected to the fact in issue or connected to another relevant fact. In essence, a relevant fact is anything that is directly or indirectly helping in proving or disproving the fact in issue. The Bharatiya Sakshya Adhiniyam also has the concept of presumptions. A presumption is the act of believing something to be true, even without having any proof. Later in this series, when we cover chapter 5, sections 78 to 93, we will discuss about the presumptions as to documents. There are two types of presumptions that the BSA has, a weaker presumption and a stronger presumption. May presume is a weaker presumption. It means the court has discretion or flexibility. The court can either consider the fact as proved until it is disproved, or it can ask for more proof. Shall presume is a stronger presumption. It means that the court must regard the fact as proved unless and until it is disproved. The court does not have any discretion or flexibility. These may presume and shall presume can have a significant effect on the outcome of the court proceedings because they can shift the burden of proof to the opposing party to disprove the presumed fact. For example, normally if a person submits a document as evidence, the court will ask for proof that the document is actually original and true and not fake. However, if the law says that the court shall presume a document to be proved, then the court will consider that document as original and true, even without any proof. Then the burden of proof gets shifted to the opposing party. Instead of the person submitting the document having to prove that it is true, the burden gets shifted to the opposing party to prove that the document is fake. As I have explained, when there is a fact in issue or a relevant fact, it does not have any legal value unless it is proved or disproved. Proved means the court has considered all the evidence and believes the fact exists, believes that the fact is true. Or in case of facts that need not be proved or may presume or shall presume situations, the court may have the option or may be mandated to consider a fact as proved unless it is disproved. Disproved means the court has considered all the evidence and believes that the fact is not true or non-existent. Not proved means the court does not have the required evidence to either believe that the fact is true or believe that the fact is false. So, if a fact is neither proved nor disproved, then it is not proved. With that, I will end this session here. If you have any questions or feedback, post a comment below. See you soon in the next part of this series. Take care and Jai Hind.